Blake Lively is doing everything in her power to, as she puts it, keep documents falling into the wrong hand.
And another problem cited by the court is that while Lively argues the subpoenas will show who was a part of the alleged smear campaign against her, the problem is the alleged negative campaign didn't start until August of 2024. So why would Blake Lively need communications in 2022 and 2023?
It's obvious that a power couple at the top of Hollywood will have some secrets, but it looks like Blake Lively and Ryan Reynolds are even worse than expected. For now, they're on a mission to prove Justin Baldoni wrong, but he's the one exposing them in turn, with a court battle in process. What new secrets are being revealed? Let's talk about how it's been going. Justin Baldoni's lawsuit against Blake Lively is over 221 pages long, showing exactly how many receipts he came with. Of course, Blake's lawsuit isn't short either. But for someone who is accused of sexual harassment, Team Justin was able to come out with several counterattacks. Let's get on with the latest issue, which revolves around whether or not to release text messages to the public.
Blake Lively is doing everything in her power to, as she puts it, keep documents falling into the wrong hand. She says there are 100 million reasons why Baldoni's side might try to leak text messages and other information. That's how much PR value that they have, she told a court yesterday at a hearing.
What many agree on is that while the latest hearings seem to be about the lawsuit between Team Blake and Team Justin, it was really about all the other high-profile people involved in the It Ends With Us drama. And the biggest focus? None other than America's sweetheart, Taylor Swift.
But underneath that surface story, in a lot of ways, this hearing was really about Taylor Swift and some of Blake Lively's co-stars like Jenny Slate or Isabella Ferrer. They are the ones who would be protected. That's not obvious on the surface. This is one of those legal issues where there's just a lot bubbling underneath the surface of what you see. And unless you know kind of the inside scoop of how the legal process works, you're going to miss that. You won't understand.
Both sides are essentially arguing over a protective order. A standard protective order is nothing special and is often placed on lawsuits or civil cases with a certain amount of sensitive information. But Blake wants something bigger than that. She wants an attorney's eyes only order.
Attorney's eyes only means only the attorneys get to see this, not even the parties. That would mean that if Blake Lively produced text messages she had with anyone, then and they were marked as attorney's eyes only, well, that means Justin Baldoni can't see them. That means also the other defendants, because I think there are 10 who are named as defendants by Blake Lively, and Justin Baldoni's PR agents are also included as defendants, and so some of them also, or all of them who are defendants, would not be able to see these documents. So it's not just about public access, and in fact, it's really not about public access. The judge's protective order already covered anything of a personal and intimate nature regarding any individual.
And contrary to what she's claiming, it's obvious that this is simply a move to protect what's left of her reputation and manipulate the public further.
The judge's protective order already covered anything of a personal and intimate nature regarding any individual. So that was already there. And remember what I mentioned about that protective order creep, I'll call it, where more and more stuff gets shoved under there. That's going to be used to keep a lot of things under seal that really shouldn't be and that aren't personal and intimate. At least in many cases, that's how it will end up working.
This comes soon after a judge refused Team Blake's demand to reveal all of Justin's text messages, calls, and emails over a period of more than 2 years. His team had a lot to say about that, pointing out how entitled her team seemed to be acting.
When they wrote in their letter to the judge, it is hard to overstate how broad, invasive, and atypical these subpoenas truly are. This is civil litigation, not a criminal prosecution, and the Lively parties are not the FBI. Yet the subpoenas seek not only the complete call and text history of each of the targets over a period of several years, no matter the sender, recipient, or subject matter, but also over the same period, real-time location information and data logs reflecting, among other things, web browsing history.
After a meeting between the parties involved, Blake Lively actually agreed to narrow down the scope of the subpoenas issued, but Justin's team still felt they were too much.
will improperly reveal the phone numbers of anyone with whom they communicated, whether it was related to this case or not. So they countered that the subpoenas should only be limited to communications between the phone numbers and the phone numbers of parties in the case and witnesses that Lively intends to call at trial. And it seems the judge has agreed with Justin Baldoni and Wayfarer & Co., writing in his order, quote, "The subpoenas of the Wayfarer parties' phone records, even as modified after the meet and confer, are overly intrusive and disproportionate to the needs of the case. The subpoenas request call and text logs between certain of the Wayfarer parties and any other phone number, in most cases from December 1st, 2022 to the present. This request implicates legitimate privacy interests."
The judge also pointed out that Blake hasn't actually given any indication of how all the obtained information would be filtered.
Even though Lively has narrowed her request to exclude the content of calls or messages, the phone records themselves would still contain sensitive information regarding which doctors, psychologists, or even acquaintances the Wayfarer party spoke to and when. And the judge found that Lively hasn't shown how she would actually separate those numbers that may be relevant to the case from those that wouldn't. And the judge doubled down that even if someone doesn't have a privacy interest, let's say under the Fourth Amendment, protection against unreasonable searches and seizures, parties still have a privacy interest in their phone records under state or federal law. And Baldoni, Wayfarer, they have a privacy interest in their communications with non-parties.
And the final nail in the coffin was that they themselves claimed the smear campaign didn't start until much later. So why would they want logs from so far back?
And another problem cited by the court is that while Lively argues the subpoenas will show who was a part of the alleged smear campaign against her, the problem is the alleged negative campaign didn't start until August of 2024. So why would Blake Lively need communications in 2022 and 2023? And then the judge writes, quote, "Lively has not provided a basis to believe that the broad discovery she seeks will reveal information regarding unknown participants in the negative media campaign proportionate to the burden on the Wayfarer party's privacy interests."
Interview. Coming back to Blake's latest demands, her lawyer had some not-so-nice things to say about Team Justin.
Parties in this case, on both sides, include people whose entire living is made off providing information to the press and content creators. There are 100 million reasons for the parties to leak information because the PR value is greater than complying with the court orders. In other words, there's a bigger advantage to winning in the court of public opinion than maybe even winning in the court of law. That seems to be a fair interpretation of that.
Blake's lawyer also said that their text messages could reveal trade secrets within the industry. One point that made sense was when she pointed out that Team Justin had subpoenaed the couple's security agency, and there was no need to do so.
This case involves what could basically be considered trade secrets. There are marketing plans, there are business strategies, there are client lists from public relations agencies, which could give competitors in the PR industry an unfair advantage if that information is disclosed. And she even expressed concerns about the potential leak of, quote, "specific security measures Miss Lively and Mr. Reynolds have taken to protect themselves and their families from this retaliatory campaign," because we know that this story has certainly circulated.
Brian Fredman, Justin's lawyer, took offense to how the other side had worded their concerns. He also claimed that what Blake Lively's team actually wanted was simply a different law for them and their celebrity friends.
It's offensive that anyone would suggest we would disregard a protective order. This is a case where no one has any intention of beating up or harming Miss Lively in any way. And Friedman went on to say that he believed the court's model protective order, which is the standard order that the federal court has, basically a template, that's protective enough. And as far as the attorney's eyes only stipulation or designation goes, Friedman argued that his team shouldn't be burdened with having to work around that, saying we shouldn't be put into a position where we're the ones that have to run to court every single time just given attorney's eyes only protection. My client has a right to defend himself. And he also argued that Lively and Reynolds' request would unfairly treat celebrities and powerful industry figures differently from everyone else involved in the case, saying it feels like what the other side is asking for is because there is a celebrity, because there are powerful people in the industry, somehow they get treated differently. Somehow there's a different law that applies to them that otherwise wouldn't apply to normal everyday people.
The judge on the case said that justice is transparent, meaning they're most likely in favor of keeping a certain level of information about the case public, especially considering the amount of attention it has.
However, he added, my clients have a right to defend themselves That is in no way abusing the victim. Judge Lyman said that he is very aware of how all of this is playing out in the media. And Judge Lyman pointed out that both sides have alleged that the other has leaked confidential information that are difficult to trace.
The judge has also stated that there is a certain level of transparency they are expected to maintain.
Friedman made a point of arguing that Lively and Reynolds were seeking to have the law bend to their desires, not necessarily the needs of justice. And justice is transparent, the judge said. Judge Lyman did not immediately rule today. He told both sides, "I'll give you my views soon, but..."
Meanwhile, the latest trial also addressed Justin's case against the power couple's publicist, Leslie Sloan. She had previously not only asked to be removed from the lawsuit, but also requested that Justin pay her legal fees. Of course, Team Justin has refused and reiterated that they have evidence against her.
He added that the case has garnered significant public interest. And he says, quote, "There is a presumption of public access in federal courthouses." The judge revealed, "Much of this information will become public as the case goes forward. For example, in motions for summary judgment, and of course at trial. There is a public interest in how the courts are being used that the court has to respect."
And many have pointed out that her claims are pretty weak, considering what she implied about Justin Baldoni.
As a direct result of the Sloan parties and their co-conspirators, the Wayfarer parties have been damaged beyond measure. The Sloan parties complain that they are unable to distinguish the allegations against them from those brought against other parties, arguing that the Wayfarer parties engaged in impermissible group pleading. Of course, it is premature at this stage to require the Wayfarer parties to specify the precise acts taken by the Sloan parties in connection with their conspiratorial scheme. A jury will determine the truth based on the evidence. Pause. This worries me. They already included evidence against Leslie Sloan in their first amended complaint. Why not remind us now about that? They have receipts. But maybe they don't want to lay it all out there yet. They claim, quote, "The Wayfarer parties have done more than enough to make their allegations against the Sloan parties clear and can easily amend their pleading to add further details based on what they have already learned."
Elsewhere, people are also starting to suspect that Team Blake is using their influence to block videos that make them look bad. J.Y. Flair, someone who once interviewed Blake, talked about it on Popcorn Planet.
The first amended complaint adequately pleads that the Sloan parties made defamatory statements of and concerning each of the Wayfarer parties, individually and or as members of a small and readily identifiable group. Those statements are not inactionable opinion because they are falsifiable to the extent they contain blah, blah, blah. Okay, remember, Leslie Sloan argued that she was just sharing her opinion that he sexually harassed her. That's not an opinion. That's a declarative statement. The Sloan party's false claims of sexual assault are sufficiently specific to constitute defamation.
Apparently, similar tactics were used during the highly publicized Depp versus Heard trial years earlier.
Wikipedia page is kind of not a big deal, but the fact that they can do that and they're starting to do that is a sign that we need to be extra diligent and careful.
I think so too. And I don't know if you spoke to Donna, the other creator that I speak to a lot too. She put out Instagram reels that were just started muted in the middle of the audio just went off. So there's these little weird things happening, and I've gotten a lot of comments lately from people saying that, oh, your videos don't show up in my feed anymore, they don't get recommended anymore. So I don't know if that's a coincidence or if it's Nick Shapiro.
It's weird. It's weird because obviously I'm not my first rodeo, guys. We did this with a Depp trial, and I remember this happening with Amber. There was a lot of tricks that they were doing.
JY said that part of the reason she's being brought up is that they cannot explain away something that happened years before the It Ends With Us drama.
I think we're starting to get in that period, and it's just the irony, right? Because Blake's like, "There's a retaliation campaign against me," and are you feeling she's doing it to us?
Definitely. I felt it was really like uncomfortable feeling, I have to say, when I noticed the things about my Wikipedia page, because they were small tweaks, so I wouldn't necessarily have noticed, oh, everything has changed. There were little tweaks of wordings and, things, articles that were referred to. The first article in the references was a People article that was kind of insinuating that I was the rude one in that interview, that I was inappropriate asking her, or not asking, congratulating her. And, so there were all these little things that made me look like I was the problem. And I think, I definitely think there's stuff going on.
Others have also talked about how the introduction of Nick Shapiro, who is ex-CIA, into the case means that things are getting even messier. Additionally, other channels have noticed issues with their videos.
But I do think, though, my interview is their major problem here, because I think they can blame all the other bad publicity.
Yep.
They can blame that on Justin Baldoni or on Sony, whoever they're saying were responsible for, her tone-deaf PR campaign, because those interviews she did during the campaign that put a very negative light, that was obviously the smear campaign doing that. But with my interview, it stands alone. And they'll do anything in their power to try and find a connection with me and Baldoni's team, because then, they're like, oh, we got her. She's on their team. And it was all a smear campaign.
Yep.
And so I do see what they're trying to do here.
Dave Neal has also talked about how Instagram might be easier to manipulate for this sort of thing, considering what went down during the Amber versus Johnny trial.
Yeah, so Blake's a new CIA guy. Is this something do you think is happening where content creators are going to be silenced or
Well, I already saw it personally myself. I mean, I literally already saw it, and I'm speaking to Billy Bush next week about this. Like, it's truly a conversation that needs to be had. I noticed a few things happening to my account last week on Instagram that have never happened in all my years, speaking out like loudly about all kinds of things. I mean, I'm an outspoken person. I speak about anti-Semitism. I speak about world news. I speak about all kinds of things. And never before have I been in Instagram jail until I spoke about Blake Lively. I mean, what in the world is happening here? And so that happened. I had a reel that my voice went literally silent the second I said her name. Why?